So what's the difference between a will and a trust? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today we're going to talk about two really important estate plan documents and what the difference is between the two of them. So if you've never created an estate plan before, a will versus a trust can be a confusing kind of thing. Maybe you're not sure which one you need or where to start. Probably you've heard about them on a podcast, or you've watched a video, or maybe you've read a blog, and you know you need an estate plan, but you're not sure what's that first step. How do we get started? When we're looking at these two documents, it's important to understand that the core of any estate plan is going to be your will, and in some cases you may want to add a trust to the estate plan as well. First of all, what is a will? So a will is a pretty straightforward document at its core, and what that is it says who receives your assets when you're gone. Now, if you have children under the age of 18, it's very important that your will also has a provision naming a guardian for your children, and usually a backup guardian as well. And you also want to likely have a trustee, maybe a trust set up in your will, so that somebody can manage the money for your children when they're under the age of 18. The will also does what we call appointing an executor or a personal representative. Now, that person's role under your will is to take that will and get it to your local circuits court, your local probate court, and show it to them and say, I've been appointed as the executor and the personal representative, and I need to now distribute the assets under this will. So it's a very important role that you need to have filled, and we usually want to have at least one or two backups in case something happens to the first choice you have selected as your personal representative or your executor. Now, that's a basic on what a will is, but what about a trust? So a trust is a little more in-depth. It's a little more complicated than a will because it's not necessarily the same document, but it acts with that will. So what the trust does, it's usually referred to when we're talking about trust as a revocable living trust. That's going to be the most common trust you run into. However, there are other kinds of trusts that may be appropriate for you, and this is where it's important to speak to an attorney. So you can have what's called an irrevocable trust, and in that case, that means the trust you set up can never be changed. And this is really an advanced estate planning tactic that not everyone needs, but it's definitely not something you want to try to do yourself. Another kind of trust we'll run into is what we call a special needs trust. So if you have a family member who has some kind of special needs and is receiving government benefits, we can create a special kind of trust to allow for them to receive money, to inherit money through the trust, but not lose their government benefits. Because if you just do a will and they inherit money from you directly, you may disqualify them from any future government benefits. So there's a couple kinds of trusts that we deal with. And what a trust is, which is a really common question, is it sets up a way to hold assets for the benefit of somebody else. So it's kind of like a business, but it's really not. So there's not separate business and everything that comes with setting up an LLC. However, a trust is holding assets on behalf of somebody else. You designate beneficiaries, who are the people who can receive the benefits of those assets. You want to designate trustees, who are the people who are going to manage the assets. And what we do with those assets is we actually convert them into assets that are owned by the trust. So if you move a house into a trust, you actually have to draft a new deed, and the new deed will say that the house is owned by the trust. The reason people will use the trust is because it allows you to keep certain assets out of probate court. Now, when we look at the probate process, it's important to understand a little bit of how it works so you can figure out if you're looking for a will or a trust in your estate plan. So the probate process is where a court steps in to help settle your estate for you after you're gone. And it's important to understand that not all of your assets are going to go through your local probate court. So for example, if at the time of your death you only have about $10 in a checking account and you have life insurance policies and you have retirement accounts, well, the life insurance and the retirement account should have beneficiary designations on them. And what happens is those accounts are then transferred directly to the beneficiary. They're not part of the probate court process. And so if you really died and the only probate asset is that $10 in a checking account, your estate may not even have to open a probate. It makes it even easier on your personal representative or your executor because there's no court filings that have to be done. But you need to know whether or not you can avoid probate in your state and whether you should. And the reason I mention this is because I practice in a variety of different states. And so, for example, in Minnesota, we have what's called informal probate, and that allows for you to have really a streamlined probate process. However, in New York, there is no informal probate, and the courts are really backed up. Even in the best of times, the courts are backed up, so that probate process can take a lot longer. So if you come to meet with me and we have the exact same consultation, but one of you lives in Minnesota and the other lives in New York, the advice I may have for you on whether you need a trust or not can be very different, because it really depends upon what your local probate court looks like and what the procedures and the policies are. And a lot of people ask me, what does the court do as part of the probate process? Well, it has a few steps that it takes. First of all, it looks to see if there's a will, and if there is a will, is that will valid? Was it signed by the person? Is it a valid will? Does it have all the correct provisions in it? The next thing the court will do is appoint the executor or personal representative. So if we have a will, that's usually spelled out in the will. If somebody dies without a will, what's called intestate, then the court has to determine who's the best person to be the executor or the personal representative. And then step 3 for the court, they're going to monitor the distributions of your assets. So if there's a will, they're going to make sure that the assets are transferred to the right people. If there is no will, then they have to determine what the statute says and where all of your assets would go. And hopefully you can see with the will, the point is you can really determine who gets what, so you're not just stuck with whatever the statute says. So if you have certain gifts you want to give to certain people, your state statute probably won't necessarily specify those, but a will can say, I want to give $1,000 to the Red Cross, I want to give $5,000 to the Salvation Army, whatever you'd like to do with your donations. And so after all this, people are going to always come to me and say, do I really need an estate plan? And my answer 99.9% of the time is going to be yes, you do. However, there will be times when you don't necessarily need one. If you're in a situation where your assets really aren't going to be subject to the probate court, everything has beneficiaries on it, maybe you own your house jointly with a spouse, it also has a beneficiary designation by being a transfer on death designation. These are kind of situations where you may not even need to worry about having an estate plan, but it's not something you're going to figure out by reading a few blogs and watching some videos. So the important next step for you is to make sure you talk to an attorney, explain to them your situation, and figure out whether or not you need an estate plan. And if you need one, do you just need a will-based plan, or do we need to create one with a trust? For example, if you have children with special needs, we want to make sure we have a special needs trust built in. So if you're not sure, if you're ready to get started and you have some more questions, you can go to my website, 𝙃𝙀𝙍𝙀𝙀. There's a red legal strategy session button on the front page. You can click that and you'll be taken to my personal calendar. We can set up a 15 or 20 minute phone call called a legal strategy session to go over where you are in the process and what are the best next steps for you and your family. If you liked this video and you found it to be insightful, please hit that like button. If you want to see more videos like this, please subscribe, and I will see you in our next video.